So first thing first, I want to thank my lawyers. I want to thank the jurors. I want to thank the judge, and I want to thank the respectful press. I really appreciate that, and I want to thank everybody at home supporting me.
You have seen the clips. Cardi B on the stand, the courtroom reacting, and pundits shouting about a $24 million lawsuit. This is a civil case about assault, battery, and intentional infliction of emotional distress after a 2018 confrontation outside a Beverly Hills OB/GYN office. Today, we will examine the claims required in California, what the key witnesses have said so far, how damages can accumulate to such a large number, and why viral testimony differs from legal proof. First, let's get something clear. This is not a criminal prosecution. No one faces jail time from this trial. The plaintiff is a former security guard named Imani Ellis. She alleges that Cardi B scratched her face with a fingernail and spit on her during a heated exchange at a medical office while Cardi was pregnant and had not yet announced the pregnancy. Cardi denies touching Ellis. She admits to an argument. She says the dispute began when Ellis approached and appeared to be filming during a private medical visit. Those are the core competing stories. Let's start with assault. In California, civil assault focuses on the reasonable fear of an imminent, harmful, or offensive contact. The plaintiff does not have to prove a completed touching for assault. She must prove that the defendant intentionally acted in a way that made her reasonably believe a harmful contact was about to happen, and that this was a substantial factor in causing harm. Think in practical terms. If someone raises a hand and steps into your space as if to strike, and you reasonably believe that contact is coming right now, that can be assault, even if the blow never lands. The focus is on the threat and the immediacy.
We are now waiting to see if Cardi B will face any charges after throwing a microphone at a fan over the weekend who had thrown water on the rapper.
Battery is different. Battery requires a touching that is harmful or offensive without consent. A shove, a grab, a slap, or spitting can qualify if the jury finds it happened and that the contact would offend a reasonable sense of personal dignity. And if the jury believes Cardi scratched Ellis or spit on her, that is enough for battery. If the jury believes there was no touching at all, the battery claim fails. You can have assault without battery if the jury finds a credible threat, but no contact. You can also have neither if the jury decides the confrontation never crossed those legal lines. Now, the claim that tends to confuse non-lawyers, intentional infliction of emotional distress. To win IIED, the plaintiff must show extreme and outrageous conduct. She must show intent to cause emotional distress or reckless disregard of the probability of causing it. She must also show severe emotional distress and that the defendant's conduct caused it. The law sets a high bar on both the conduct and the level of distress. Rude or insulting behavior is not enough. Ordinary anger is not enough. The conduct must exceed what a civilized community would tolerate, and the distress must be serious, not fleeting embarrassment. With the elements in view, look at the evidence that is public so far. Ellis says she suffered a facial scratch that required cosmetic repair, that she was spat on, and that she lost her job because of the incident. She describes humiliation and emotional trauma. A receptionist who was present testified that she did not see a physical fight and that the confrontation was mostly words. Cardi testified that she was 4 months pregnant, that she wanted to avoid any physical conflict, and that she did not touch Ellis. Jurors will weigh credibility. Did the receptionist have a clear view? Do medical records match the claimed injury? Are there photos, videos, or contemporaneous notes? Do employment records support a claim for lost wages? Juries make decisions on that kind of evidence, not on a volume of online attention.
In a civil lawsuit, it's a $24 million civil lawsuit, and what we now know is that a former security guard at the medical center where the rapper had an appointment claims that Cardi B attacked her in an incident that led to her getting fired.
Why did the testimony go viral? The answer is attention economics. Cardi B is a celebrity with a massive audience. She speaks directly and does not sand off the edges. Clips that show pushback during cross-examination, jokes about wigs after a question about hair, or a remark about pregnancy limiting her physical abilities will travel because they are vivid and short. None of that is a legal element. Judges instruct jurors to ignore media and to decide the case only on evidence they see and hear in court. That instruction matters because virality and reliability liability are not the same thing. Damages are the next piece. Civil cases divide damages into categories. Economic damages cover measurable losses like medical expenses, therapy costs, and lost wages. If Ellis proves that the incident led to a job loss, a jury can award both past income and a reasonable estimate of future income that was lost. Non-economic damages compensate for pain, suffering, humiliation, and mental anguish. These numbers are not set by a formula. Jurors use their judgment under instructions from the judge. Finally, punitive damages punish and deter if the plaintiff proves by clear and convincing evidence that the defendant acted with malice, oppression, or fraud. Punitive damages are not automatic. They require a higher level of proof and a finding that the conduct warrants punishment beyond compensation. So how does a demand reach $24 million? Picture a theory that includes six-figure medical and therapy bills, several years of lost earnings with benefits, and a large non-economic number for emotional distress and reputational impact. Add a punitive request size to get the attention of a wealthy defendant. You can reach 8 figures on paper. That is the math behind many celebrity cases. The important point is that a demand is not a verdict. The jury must link each dollar to evidence. Jurors can and do cut numbers that feel speculative or untethered to proof. Witness credibility will decide most of this trial. Start with the receptionist. If jurors view her as neutral, her account that the clash was verbal helps the defense on battery. Medical records will be tested for timing and consistency. If the first note appears days or weeks later, the defense will argue that causation is weak. If photographs exist from the day of the incident, those images will matter. Employment files will be relevant to lost wages. The defense will look for other reasons for discipline or separation. The plaintiff will try to tie the job loss directly to the incident and the fallout from it. Each side will use cross-examination to sharpen or soften those points. Pregnancy is part of the story for both sides. Cardi points to pregnancy as a reason to avoid physical contact, which supports her denial of touching. The plaintiff may argue that filming a pregnant patient outside a medical office was not a threat and that her conduct was within job duties, while the defense may argue that the approach invaded privacy and escalated risk. None of those arguments decide the elements by themselves. They provide context that jurors can use when they decide whether the legal thresholds have been met. What about the courtroom tone? Memorable answers can humanize a witness. They can also annoy jurors if the exchanges feel disrespectful. Lawyers sometimes try to provoke a reaction to test credibility. Judges control that space. If the temperature rises, a judge can instruct counsel to move on, can strike questions, and can remind the jury that jokes and sarcasm are not evidence. The safest bet for any witness is to answer directly, stay consistent, and avoid performing for the gallery. Jurors notice when someone is trying to win the internet more than the case. Why did this case take years to reach trial? Civil litigation often runs on a slow clock. The pandemic created a backlog. Pre-trial motions and discovery take time. High-profile parties add layers of scheduling, security, and negotiation that do not exist in routine cases. None of that changes the proof needed at trial. The plaintiff still must establish each element with evidence that the jury finds credible. The defense still must show reasonable doubt is not the standard and that any gap in proof defeats a claim. Now, the realistic outcomes. The jury could return a defense verdict if it finds no touching and no extreme conduct. The jury could find assault but not battery if it believes there was a credible threat but no contact. The jury could find liability and award modest economic and non-economic damages without punitive damages. The jury could also award punitive damages if it finds clear and convincing proof of malicious or oppressive conduct. After any verdict, the judge can consider motions to reduce a legally excessive award or to order a new trial. Appeals can follow. That is how the system checks extreme results. Here's the method I want you to use when you watch a high-profile civil case. Print the jury instructions or write down the elements. For assault, ask whether the conduct created a reasonable fear of imminent harmful contact. For battery, ask whether a harmful or offensive touching happened without consent. For IED, ask whether the conduct was extreme and outrageous, whether intent or reckless disregard was proven, whether the distress was severe, and whether causation is solid. Then map each witness and each document to those elements. If a piece of evidence does not help answer an element, set it aside. Where does the viral testimony fit? It shows style. It does not prove an element. A smart closing argument will bring jurors back to the list of elements and will ask jurors to sort the evidence into those categories. Expect the plaintiff to argue that workers deserve safety and dignity, that words can turn into threats quickly, and that a celebrity should be held to the same standard as anyone else. Expect the defense to argue that words alone do not make assault, that there was no touching, that the distress was not severe, and that the numbers are not anchored to proof. Both sides will likely quote the instructions and will ask the jury to apply them without fear or favor. The clean takeaway is simple. Civil assault and IIED have clear elements, witness credibility, and documents carry the most weight. Large demands are advocacy, not destiny. Viral moments are not verdicts. If you want to forecast outcomes, use the law as your map and treat every clip as a small part of a much larger record. Thanks for joining us today at Due Process Daily. Throw us a like and consider subscribing to the channel to help us grow.